Welcome to the show. I am your host, Daniel, and today is Judge Victoria Shackelford, and cases are being heard in her court. And I do appreciate the comment that I'm great court coverage. Yeah, I'm doing my best with it. So let's get this started. Share my screen. Yes, I'll be here. I'll have the mic muted because I have to watch for ads. So I am here. So let me make this bigger. I'm going to mute my mic now, but I'm still here.
All right, we're on record again. This is 2433910M.
Okay, under behalf of probation.
Morning, Your Honor. Jeffrey Fanto on behalf of Ms. Buford. Wait formal reading, request all warrants be recalled.
All right, the warrants will be recalled.
Judge, we would ask that this matter be treated as a violation hearing date. I've had discussions with my client, I've had discussions with the court. And I had discussions with Mr. Zick this morning as well. Ms. Buford understands she has a right to have a hearing in this matter. And she understands the allegations that she missed her show cause, missed her orders appointment. She's prepared to enter a plea of guilty to that her 771 would be amended to a 3-month period, which is now passed. That would be closed successfully. The balance of the fines and costs on that would be waived.
Ma'am, do you understand all that?
Yes.
All right, Ms. Buford, don't come up here with the attitude. Just shrug it off. Listen, ma'am, you understand you're here today for a violation of your probation?
Yes.
Is that a yes?
Yes, ma'am.
All right, you understand there's an allegation that you failed to appear for your orders on your probation.
Yeah, yes. Ma'am.
I have the recommendation. I'm looking for the actual violation. So knowing all of that, ma'am, how do you plead to the allegation you failed to appear for your orders appointment on 4/4 of 25 and 4/14 of 25? Has anyone forced you to get you to plea?
No.
She posted a payment and it should have been applied to the other case, and it was applied as a cash bond on this case.
It should have been applied to her.
Yeah, it should have been applied on
May
two.
incorporate another file, I'm not sure, but it just should have been applied to her payment.
Yeah, to 266. I don't see that she's picked up any other cases or anything.
No.
So you're keeping that status. I'm closing the probation. I'm allowing you to keep that status. But you're, the way you've behaved in this court is so egregious. Do you know, like, you're grown. How old are you?
22.
You're 22 years old. You cannot come into places, a court, the one place in the world I could put you in jail. The one place you can't come into screaming, yelling, screaming the F word at people is here. You can't do that. Are you confused by that?
Honestly, I am a little confused by it because I was with my mother and I don't cuss in front of my mother. So I didn't scream any F words or I didn't say any F bombs or disrespect anybody because she was standing right next to me.
You weren't disrespecting anyone down there.
No.
So why do my court officers have to come out? And why do all the notes in the file on January 3rd, you called up to the court. This is another staff member. This is just another random staff member in the building writing a note. Very, very rude to all staff, screaming in my ear about her ticket, wants to know why she has a felony. She would not let me talk. These are the ROA notes. Then you cancel your appointment twice. My probation department's advised me that, you know, you and Kelsey, you had worked with Ms. Havner. She had to hang up the phone because of your behavior. And then after that, you called back again and you spoke to a clerk in the probation department who doesn't know anything about your case. And you were screaming at her too. I've got notes from so many different clerks in this file. Asked what I can help her with, and she began screaming at me. She wanted to talk to a supervisor. I tried to transfer, but she refused to talk to her. I had to terminate the call because she continued screaming and using profanities and would not let me speak. I mean, it's like there are note after note after note. I know that they had to call the court officers to the probation department because of your behavior in probation yesterday and demanding that I see you forthwith. I have dockets and you were on it at 1, and then you chose not to come back at 1. And it's like, this was a minor, you know, overall offense. I mean, I know that because I sentenced you immediately from the bench and just gave you non-reporting probation. All you had to do was come in and do your orders with Ms. Havner, not pick up any new cases. And you can't do it. You missed that appointment 2 times. It's like a lack of self-control. Everyone here is the bad guy. So your payment plan continues on the driving while license suspended and the civil infraction for expired plate that you have. On this case, I'm closing the file. You will keep your diversionary status. You've got no prior criminal history. You're young. I don't want to make you a criminal, even though it seems like you want that on your record. I'll waive the balance because you're doing 5 days jail forthwith.
But she report on Friday.
No. Ma'am, an appeal to circuit court may be taken within 21 days of the date of sentence or is permitted pursuant to MCR 6.625 parent B. If the sentence includes incarceration and you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint the lawyer to represent you on the appeal. If the request for the lawyer is made within 14 days of date of sentence.
Thank you.
You taking her to jail today?
She's going right now.
At least get a hug or something?
No, but if she has anything she needs to give you, she can hand it to the court officer. Ma'am, I see where she learned it.
No, she didn't learn it from me.
Hey, hey, Mom, go! Mom, go!
Board on long floor.
Okay, this is Mercedes Bennett, People versus Mercedes Bennett, 242302 SD. Eric Wagman on behalf of probation.
For your Honor, Jeffrey Cantor on behalf of Ms. Bennett, wait for all reading, stand mute relative to violation. Just requesting an adjournment of 2 weeks. Ms. Bennett wishes to retain her own counsel.
Okay, so I'll enter a not guilty plea for purposes of arraignment. Ma'am, did you go over your advice of rights form with your attorney?
Yes.
This one, did you understand your rights?
Yes.
And did you sign and date the back of this form?
Yes.
Okay, so this is the second allegation. Well, she pled on her last one on 4/28. She just got,
It was in effect that day.
1 sec. So she just was sentenced when?
March.
Sentenced in March. We have her second, this one's an allegation, it's not been proven, but second alcohol related offense. This is a second offense that she has, her second drunk driving. So she's receiving a personal bond and we'll adjourn it. Is 2 weeks enough time?
Yes.
All right. We'll send you notice of that new date. I'm saying 2 to 3 weeks. It'll be up to the clerk to see when they can fit it in. She's also getting put on a scram tether today. You're getting put on a scram tether today. That's a condition of your bond. So you'll go with Ms. Wagman and she'll contact the tether people and get them up here. We'll have an alcohol tether on you until your violation is held. Understood?
Is there a way I can take like a blower home?
Nope.
I go to school and work.
So is everyone else. You're getting a tether. You're not, this is the second drinking allegation that you've had in weeks. And it's your second drunk driving and you're getting a scram tether today, or you're going to county, so I make sure you don't kill someone. Your choice.
When I came in front of you on the last time, I had already spoken to her. I thought we was gonna handle the matter right then and there. I haven't drunk since I left, and you said no alcohol. I haven't drunk. And I also has been going to see my therapist, and I also has been AA twice a week. I have not had any drinks since I left out your courtroom when I saw you the last time. I thought we was gonna take care of that when we was in here.
The reason why we did not take care of it that day is because there was a lab pending, because she sent it to the lab to confirm it, because she did deny at first. When we met after the violation the last time for our meeting, she did admit to her alcohol use. However, since the lab was still pending, I did not have it scheduled.
Okay, so it's got sent to the lab. We couldn't do anything until we got the confirmation of scram tether until hearing. All right, we're all set.
Is it anything, any other thing?
You can go to jail. You want to sit in county, so I know you're not going to kill anyone until your next hearing? I can give you a high cash bond and you can sit in jail for 2 to 3 weeks while we wait for your hearing, or you can get on a scram tether. What you pick.
Can you give me 1 second while I call my attorney?
No, she's getting a scram tether today. Okay, you're gonna go with her. We'll set in a hearing. You can contact your attorney. You're going on a scram tether today, or you're going to Wayne County Jail.
Thank you, Your Honor.
Your Honor, good morning. Elias Muad, P41632, representing Mr. Calhoun, who I yelled at more than once since I started representing him.
All right, Mr. Calhoun, good morning. Can you tell me your first and last name?
Good morning, Ricardo Calhoun.
All right, it's a time and date set for sentencing. Have you had an opportunity to review the pre-sentence investigative report?
Yes, Judge, there's no corrections, additions, or deletions. A very thorough report. I'm Mr. Calhoun.
Mr. Calhoun, your record is abysmal. It is so bad. It is so bad. I mean,
Well, what's funny, Judge, is he's got a pretty good history of doing a lot of charitable work and stuff. Like on paper, he's got some good things going on in his life, but you know, and I've gotten to know him, and I can tell him, is he done? I asked him this morning, are you done? His pastor, believe it or not, yelled at him. His wife has yelled at him. They all know what happened here. And
but it's almost like this behavior is like an addiction for you or something, because this is the thing. I don't know how you find a job. Like, I don't know how you keep a job with, and I mean, it looks like you do good work. Like what you do is important, right? For a incredibly disadvantaged community. So you do really good work. And then I just look at this, your record for theft, and they're misdemeanor offenses for the most part, but your record for theft, I was 3 years old, and I am not a young woman. And I was 3 years old when you started committing thefts. And Mr. Calhoun, when I look at this, like this tells me that like, I don't know what is going to help you learn. Like if you're a good person, like this is something we learn in law school. You're going to hear my lecture. There are 2 kinds of crimes a person can commit, right? There are crimes that are wrong because the government says they're wrong, right? They're wrong, like let's say driving on a suspended. The government says you have to have a license to drive, right? And if you violate that law, it's still a violation of the law. And that doesn't mean it's not serious, but it's only wrong because the government has some structure or agency that says it's wrong, right? And then there are other crimes we learn about in law school that are bad because they're morally wrong, right? Driving on a suspended is wrong because the government said so. Theft is wrong because it's wrong. And you're not Aladdin. You're not out stealing bread or food, which I would view very differently. This isn't for survival. this shows me that you have a dishonest heart. And that, I mean, that any judge or attorney or anybody that looks at this, like this is all of your criminal convictions are wrong per se. Like they're just wrong. They're not wrong because the government said they're wrong. They show bad character. And for someone who does the type of work you do, it's just like the people that you work with, if they steal, they're stealing food, right? These people are stealing to survive. You're stealing for a new pair of slippers. Like you know better. And I know you know better. And it's just incredibly disappointing to see someone that has your history back in front of a court. And like, you've done this before, you've been to this rodeo, and it looks like you had a gap of a decade of nothing, right? No offenses whatsoever. That doesn't mean you weren't doing it. It meant you weren't getting caught. And because I don't think someone just walks into a place one day and says, I like those, and takes them, right? And you have income.
We've got great news.
And you have restitution in the amount of $2,000. So was this you're lucky this isn't a felony.
Judge, the good news, he has $2,000 today to pay on the restitution. I was one of my requirements that we talked about when he pled, is I wanted him to have this, no matter what you do, but I wanted him to have the restitution, $2,000. It's a little over $2,000 fines and costs, but he spent today.
I just expect that someone your age, with the type of, I keep going back to the type of work you do, but like, I'm shocked really to see someone with doing what you do every day and watching people who are suffering, and then you go out and do it for what, right? Is there anything else that anyone wants to say?
Yeah, I'd like to say something.
Go ahead.
I wrote a few things down so I wouldn't forget, but one of the things that sticks in my head is from Forrest Gump, stupid is what stupid does. And I really need people to see that no excuse. But also, I don't think I ever really thought about it. I also be destroying my family. And I haven't told my younger kids about this, and maybe one day I will, but.
Well, I mean, it's a teaching thing for them, but like, this, like you're grown, I'm grown, we're all grown. Kids learn from what they see. And they learn from what they see, they learn from what they're surrounded by. And you can say, do as I say, not as I do. But if dad's coming home with things dad can't afford, right? I mean, at some point, kids aren't stupid. They're not. Kids are probably smarter than us. They pick up stuff that we're so used to living in the world, we don't notice. They do. The recommendations for probation, I'm going to follow the recommendation, but I expect strict adherence to this. You're going to do what you have to do to get out of probation. You didn't get a special status or anything, so you'd be eligible for termination at the halfway point if you complied with everything. You have a fine of 50, court cost of 50, state cost of 50, and a crime victim's rights fee of 75, probation oversight fee of $450, community service fee of $10 per day for a total of 50, and restitution in the amount of $2,056 for a total of $2,781. If you pay what you have today, and then you can have a payment plan for whatever the remainder is. You have 12 months probation. You'll do 5 days of community service. That's 40 hours. You'll do it in the city of Taylor. You harmed the city of Taylor, you'll do it in the city of Taylor, and you'll provide proof. Make sure you get your agency approved before you start going. You'll do 5 days or 4. I just told you that. You'll attend one CASA support group meeting per week and provide proof. I'm guessing that's a Shoplifters Anonymous class. You'll abstain from the use or possession of alcohol or controlled substances for the term of your probation unless they're prescribed by a physician, and documentation will be required. And you'll be subject to testing, random drug and alcohol testing, or testing on demand.
You understand what on demand means? If they say you gotta come in and test, you gotta test. If they find anything, then, you know, you're gonna be in front of the judge.
Do you live in Taylor? Do you live in Taylor?
Good boy.
Okay. So you'll be tested at the demand of the probation department. If they call you, you better answer or it's a violation. You'll submit to a mental health evaluation as directed by probation and follow therapist recommendations and provide proof that might be helpful for you. You'll complete theft prevention classes as directed by probation through Crossroads Recovery and provide proof and follow all therapeutic recommendations. Any other ancillary services that are deemed warranted. You can't go into bars or liquor stores. You can't surround yourself with drug or alcohol using peers. You cannot go into JCPenney. You're to maintain employment and provide proof. You can't shop without another adult. You can't operate a motor vehicle without a valid license. And were you arrested and printed?
Yes, I went in there. Yes.
What's that?
Yes.
I mean, I'm hoping, do you go to church?
Yes.
You're a religious man?
I like to think
All
so,
right.
but,
You know the commandments? How far down is not stealing?
I think about 3 or 4.
Yeah, it's like at the top of the list, like after don't kill, right? I mean, think about that and think about how you want people to view you and the kind of person you want to be. I mean, I don't know if I'm going to change you by lecturing you for 3 or 4 minutes, but it's, you're too old for
I'm
this.
definitely too old.
All right, we're all set. You can go down to probation department before you leave. Go downstairs to the right to set up your appointment to meet with them, okay?
Appreciate it, Judge.
Yeah.
Thanks for counseling him like I did. Mr. Calhoun, call me if you need anything, okay?
Okay, thank you.
Ryan Reynolds here from
This is 252469 FY, State of Michigan versus Jamie Williams.
Good morning, Judge Puddle with NDSBA 3424. And on behalf of Williams, please state your name.
Jamie Williams, Your Honor.
All right, it's a time and date set for preliminary exam. Are the people ready to proceed?
Yes, Your Honor.
All right, any preliminary matters?
There's just one. It's a minor issue. At the last probable cause conference on the preliminary examination, this court ordered mandatory disclosure of a number of items. The written statement of Ms. Reinhardt and police reports associated with past incident reports, the body cam footage, and the written reasons for the denial of those previous warrant requests. I have received the written statements, police reports, and the body cam, but the prosecutor is now refusing to disclose the warrant denial requests.
Your Honor, all right. To be clear, I never said the reason for the denial. I said you had a right to have the investigators' reports. Like, that's what I wrote down. Other police reports, investigators' reports, statements, body cam to be produced. And I knew that they were prior denials, or I presumed they were, but I mean, I didn't give, whatever their rationale was, I didn't say she had to disclose that.
Your Honor, I advised opposing counsel here that I, the supervisor, had told me that that's considered attorney work product, which is why I didn't.
Yeah, I mean, well, that's what I would think, because that's your work product. The investigator's report is not your work product.
No.
But the rationale for the prosecutor's office denial, I think, would be. So do you have the reports?
I do.
All right, let's go. How many witnesses?
I have one at this time, Your Honor.
What's that?
One.
All right, call her up.
And people call Katie Reinhardt. There are a couple of people in the courtroom I just asked for the trial sequestration.
Yeah, we'll have an order of sequestration. I don't know that anyone here is here on this case, are they?
Prosecutors, Katie Reinhardt. He didn't physically touch you on April 24th, correct?
Objection, Your Honor. Hang on, I'm gonna object. Matter is irrelevant.
This is a prior incident that's not involving this incident. Is that correct, Mr. O?
It is, Judge, but she makes statements about the relationship that are going to be relevant to the May 9th incident.
All right, I'm gonna allow it. If he's not using it to, I mean, it's his client's prior acts if he was, you know, going there, but it sounds like he's going somewhere. So let's see where he's going.
You didn't call the police after the April 24th incident, correct?
Yes.
You went to the police station, correct?
Generally, that.
You went down to the Taylor Police Department, correct?
Yes.
And you told the officers the reason you didn't call was because you didn't have a phone, correct?
Yes.
But you just testified a couple seconds ago that you were texting your mom on May 9th, correct?
Yes.
Okay. When you went to the Taylor Police Department on April 24th, you spoke with Corporal Graves, correct?
Yes.
You said that you were going to evict Mr. Williams, correct?
Yes.
That you were going to get a PPO against him, correct?
That's it.
Okay. Now let's talk about the May 9th incident. Around this time, you and Mr. Williams were having relationship problems, correct?
Yes.
You two would often argue, right?
Yes.
You would accuse Mr. Williams of cheating, correct?
Yes.
Of him being lazy, correct?
Yes.
But throughout your relationship, Mr. Williams has bought you a bed, correct?
Yes.
Bought you a TV, correct?
Is that a yes?
Sorry.
Is that a yes?
Yes.
Mr. Williams has tried to break up with you several times, correct?
Objection, Your Honor.
What's the motive, Judge?
No, these aren't even about the prior report.
Well, none of this is about the prior report. Now he's talking about
The relationship.
just in general in their relationship. I'll allow it.
Mr. Williams has tried to break up with you several times, correct?
Yes.
Because he was tired of arguing, correct?
Correct.
He was tired of the cheating accusations, correct?
Correct.
And you didn't want the relationship to end, correct?
That's correct.
Because you love Mr. Williams, correct?
Heard that.
Because you loved Mr. Williams, correct?
Yes.
You wanted to make the relationship work, correct?
Correct.
Okay, but you kept arguing about other women, correct?
Correct.
Okay. The incident on May 9th, he never touched you with the knife, correct?
Correct.
He didn't hit you, correct?
That's correct.
Okay, was anybody else home on the May 9th incident?
I'm sorry.
Was anybody else home on the May 9th incident?
Yes.
After this incident happened on May 9th, you didn't call police, correct?
Yes.
You go down to the police station, correct?
Yes.
That same day, correct?
Is it a yes? Sometimes I can't hear you. I need to make sure we get your answer down. Did you say yes?
Yes.
Okay.
Now you had a phone at this point, correct?
Yes.
Why didn't you call the police?
What's that?
You had a phone on May 9th, right?
Yes.
Why didn't you call the police?
I was afraid.
Okay, but you drove down to the police station, right?
Yes.
And at this point, you still haven't started the eviction process, correct?
Sure.
And you continue living together, correct?
I'm sorry.
And you continue living together, correct?
Yes.
You still didn't get a PPO, correct?
Yes.
Okay. You also filed a third police report on May 14th, correct?
Yes.
Okay. You were at home, right?
Yes.
You called the police, correct?
Yes.
You two had an argument, right?
Yes.
And Mr. Williams was still living at your home, correct?
Yes.
What was that argument about on May 14th?
I'm sorry.
What was the argument about on May 14th?
I don't remember.
Okay. But police are called to your apartment, right?
Yes.
And when the police arrived, you're sitting in your car, right?
Yes.
Before you moved to Taylor, you lived with Mr. Williams in Monroe, correct?
Yes.
And when Mr. Williams lived with you in Monroe, you got a PPO against him, right?
Yes.
Okay. So you moved from Monroe to Taylor in about January of 2025, correct?
That's correct.
So you've had a PPO against Mr. Williams this entire time from the start of 2025, correct?
I got to Taylor.
You're denying that you told police officers that you got a PPO against Mr. Williams when you lived in Monroe?
No.
So you did get a PPO against Mr. Williams when you lived in Monroe, correct?
No.
Okay, permission to approach, Judge?
Yeah. For what purpose?
For impeachment. She tells the police officers on May 14th that she's had a PPO against Mr. Williams since they lived in Monroe.
You can approach her with it. Have you seen
I
that?
did see it, I just don't know exactly what it's.
Yeah, it's case -25-14280.
Is it a Taylor PD report?
It's a body cam footage of her statement.
Okay.
I have no objection.
All right, go ahead.
For the record, showing opposing counsel, permission to approach, Judge.
Yep, and continuing permission.
For the record, starting at body cam footage label D01A4855P at 1 minute and 12 seconds.
So the no contact, that was through Monroe Court, and then you guys moved from Monroe to here? But you did move with. Okay, so we have a few domestics against us.
So, Ms. Reinhardt, you told the Taylor Police Department that you had a PPO against him when you either lived in Monroe or Southfield, correct?
Yes.
And that was before you moved to Taylor, correct? Yes. But you told Taylor Police Department on April 24th and May 14th that you were thinking of getting a PPO against him, right?
Yes.
You agree with me that those two statements are inconsistent, right? Okay. And despite having a PPO against him, you two moved in together, correct?
Yes.
You told the police you moved in together because the PPO wasn't served, right?
Yes.
Why wasn't the PPO served when you lived together?
It wasn't served until last month in August.
My question was, why wasn't the PPO served against them when you two lived together?
I don't know.
What do you mean you don't know? Ms. Reinhardt? lived with you, it would have been easy to serve him, right?
Yes.
But you didn't. Why not? Ms. Reinhardt, you're under oath. You have to answer the question.
Ms. Reinhardt, why did you not serve him with the PPO? Just answer the question.
I already did, was,
Let me ask this. Let me help. When did you get the PPO?
I got it when we moved to Sawyer.
Do you know approximately what month?
She testified it was in early 2025.
Early 2025. Is that accurate? In early 2025? You got the PPO, yes or no?
Yes.
Why, the attorney is asking you, why did you not serve the PPO? Why didn't you serve it?
I was afraid to serve it.
But you continued dating him, correct? Yes?
I'm sorry.
You continued dating Mr. Williams, correct?
Yes.
Mr. Williams kept trying to break up with you, correct?
Sure.
You said you didn't want the relationship to end, correct?
That's correct.
Even after you got the PPO, right?
Yes.
Okay. You could have evicted Mr. Williams, right?
Yes.
It was your apartment on Princeton, right?
Yes.
You never initiated the eviction process, right?
Yes.
Despite telling Taylor police officers on April 24th and May 9th that you would evict him, right?
Yes.
In all three of these incidents, April 25th, May 9th, and May 14th, Mr. Williams never touched you, right?
Yes.
He never physically hit you, right?
Yes.
Mr. Williams wasn't arrested until August 19th, correct?
That's correct.
You called the police on him again, correct?
Yes.
Told the police that Mr. Williams was home, correct?
I'm sorry.
He told the Taylor Police Department that he was home on August 19th, correct?
Yes.
The last time you filed a report was May 14th, correct?
Yes.
Between May 14th and August 19th, you continued living together, correct?
Yes.
Things were going well between you two, correct?
Yeah.
Still dating, right? Yes?
I'm sorry.
Between May 14th and August 19th, you were still dating, yes?
Yes.
But in August, you started having problems again, right? Around that time, you became suspicious that Mr. Williams was cheating on you, right?
Yes.
Okay. You two had a big verbal argument, right?
Yes.
Mr. Williams said, if you're going to accuse me of cheating, I'm just going to go do it, right?
Yes.
Mr. Williams contacted an ex-girlfriend, right?
I'm gonna object, Your Honor.
Oh, it's relevant.
I don't think I heard what date you said.
August 19th.
Okay, I didn't know if that foundation was set up.
Okay, carry on.
Thank you, Judge. The last question was, Mr. Williams said, if you're going to accuse me of cheating, I'm just going to do it, correct?
Yes.
He contacted an ex-girlfriend, right?
I'm sorry.
Mr. Williams contacted an ex-girlfriend, right?
Yes.
The woman he was seeing before you, right?
Yes.
Her name is Gloria Ramon, right?
Yes.
You find out about Gloria Ramon, correct?
Yes.
By going through his phone, right?
Yeah.
You constantly go through his phone, right?
Yeah.
To check if he was cheating, right?
Yes.
And when you caught Mr. Williams contacting Ms. Ramon, this was a big deal, right?
Yeah.
Confirmed all your suspicions, right?
Yes.
And you were angry, right?
Sorry.
You were angry about him cheating with Gloria Ramon, correct?
Yes.
Once you find that out, you and Mr. Williams are, first of all, you find that out when you're at your Princeton apartment with Mr. Williams, correct? That was on August 19th, right?
Yeah.
Okay. Mr. Williams and you have a big verbal argument, right?
Yes,
Nothing gets physical, right?
I'm sorry.
It does not get physical, right? Mr. Williams calls his mom to come pick him up, right?
Yes,
And says that he wants to break up again, right?
yes,
This is the final straw, right?
yes,
Okay. You didn't want to break up with him, right?
yeah,
You said you wanted to make the relationship work, right?
sorry.
You said you wanted to make the relationship work, right?
Yes,
You said that if he broke up with you, that you would kill yourself, right?
yes.
I'll be right back, everybody. Hold on just a minute. Okay, I had to take a quick potty break, but I'm back. So let's get this started again.
Okay. You would routinely threaten self-harm if you tried to break up with you, correct?
Yeah.
You would only call the police when you were mad at Mr. Williams, correct?
Yes.
Okay. No further questions.
Redirect?
Yes, Your Honor. Okay, great. So, Ms. Reinhardt, on May 9th, which is what we're here for today, you had a phone. Did you have a phone?
Yes.
Had it been broken by Mr. Williams in the past?
Yes.
Was this a new phone that you bought? Or got somehow?
Yes.
So in the incidents that you reported, did you report them to the best of your belief?
Sure.
In the incidents, so this incident and those prior incidents that had happened, when you reported them, did you report them to the best of your belief? Were you truthful when you reported them? Did you said your PPO was served in August, did you say?
Yes.
Was it this year?
Yeah.
So you said you were afraid to serve the PPO. Why were you afraid of it?
Sure.
When you said you were afraid to serve the PPO, why were you afraid?
I thought he might hurt me.
And the eviction, was there a reason why you never actually evicted him?
I things to work out.
I'm sorry, can you repeat that?
I wanted the relationship to work.
And on the date of this incident, were you the one where there was the knife involved? Were you afraid for your life when he did that?
Yes.
And when you reported the other incidents, did you do so because you were afraid of him?
Yes.
I have no further questions.
Any redirect based on that?
No recourse.
All right, can this witness be excused?
Yes, Your Honor.
All right, ma'am, you're all set. You can leave the courtroom.
Okay.
And Madam Prosecutor, do you have any other witnesses?
No, Your Honor, that was just him.
Are the people resting?
Yes.
Counsel, any witnesses?
No defense witnesses.
All right. Anything by way of argument?
Yes, Your Honor. The witness did testify that it was pointed at her that she was about a foot away from the defendant when it was pointed at her that she was in fear of her life. I know other reports were mentioned here. She did say that she was in fear of him, and that was the reason why she reported them. She did say that she was truthful when she reported them, but despite all of that, I want to bring the court's attention back to the actual incident, which happened on May 9th. Really, what the prior reports show is just a pattern of aggression in this relationship, and I would move for a bind over as charged based on that testimony.
Counsel, can you make a very brief argument?
Yeah. There's a lot to say. I'll just focus on the important things. When we're assessing credibility, which this court has a duty to do under People v. Anderson, we look at whether or not the witness is consistent in her statements, whether or not she has a particular motive, fabricating. She was not consistent in her testimony. She said she didn't call the police because she was on the phone. She's broken in the past. She's texting her mom. She says that she can get a PPO, but later, a couple seconds later, says that she's had a PPO this entire time. The reason she hasn't served it is because she's afraid. But it's lied to the police when Mr. Williams is not present or around her or would be aware of those conversations and says that she doesn't have a PPO against him. The biggest concern and red flag here really is, while this PPO is active, they're in a dating relationship, they're moving together from place to place. And the timing of the disclosure is the biggest red flag. She goes down to the Taylor Police Department on April 24th and May 9th. But then on August 19th, when she finds out that Mr. Williams is cheating on her with an ex-girlfriend, she says that's the final straw and then makes these allegations and has him arrested. There's no physically corroborating evidence for any of these allegations. And she has a strong motive to fabricate these charges to get revenge against Mr. Williams. I know the standard is probable cause, but
You can rest.
okay.
All right, thank you. Under People versus Anderson, this is 912 Northwest 2D 503 501 Mish 175. The district court judge has the authority and the obligation to determine credibility of witnesses, as well as probable cause. The witness in this case that was put up by the prosecutor is the only evidence that was submitted to this court. There was nothing to corroborate the testimony of the complainant, Kaylee Reinhardt. I don't know if I've ever seen a less credible witness in my time as a judge. She testified that her and the defendant had an argument. He came in, he pointed a knife at her, said he would kill her, and then he was about a foot away, then he left, and she stayed, texted her mom, and contacted the police department. It was clear that the complaining witness testified she had a history of calling the police on the defendant. And the last questions defense counsel asked her is, did you only call the police on him when you're mad? And the answer was yes. It was clear that this was a volatile relationship with allegations of cheating in it. And on multiple occasions, the two of them would fight and a police report would result. She made inconsistent statements to law enforcement about having a PPO. She did not have a PPO. I do not believe that she continued to live with him because she was afraid to serve the PPO. It only became an issue when he said, we're done. I mean, she continued, she eventually got a PPO sometime in 2025, continued to live with him up to August. She testified in all these arguments, he never got physical, that she always wanted to make the relationship work. She threatened to self-harm if he broke up the relationship. There are just so many red flags in her testimony. I mean, it's just all of her testimony was is red flags. I don't believe she's credible at all. I don't believe this happened. I believe based on her testimony, lack of credibility and lack of corroborating evidence that Mr. Williams wanted out of a relationship, and this was the price he was going to pay to get out. Case is dismissed. Okay, now we have very patient Mr. Tyra and his counsel and the complainant on that case. Let me see if
you walk up
on 251799FY, the People versus Julian Santana.
Good afternoon, Your Honor. Donna Silva on behalf of the people, Suite 7439.
And good afternoon, again, Your Honor, Viviana, 44626, appearing on behalf of Mr. Julian Santana, who's also present. Sir, state your name for the record, please.
Julian Santana.
All right, so we've already covered all of the exam information. My understanding is there's an allegation, there's a bond violation.
Yes, Your Honor, and before we get to that, I did want to give the court an update. I checked that Instagram account just to see what sister counsel was saying, if it's not his account or anything. Upon checking it, there's actually new information I have supplied this to sister counsel.
and I can show the court, it's actually a footage of another picture with Mr. Santana holding two guns. You can see his GPS tether, you can see his cross neck tattoo, not his face, but you can see the identifying unique tattoos. And another post, it has and these are 24-hour stories. They're only lasting 24 hours and then they're erased. Another one is a timer, a countdown to court today. The timer has gone off, meaning he's in court today. Another picture of like a picture taken a person of their outfit, and you can tell this person is wearing a black suit with very unique shoes that I must put on the record. They're black, like Converse type sneakers with silver spikes on the tip and some red. You can see them very clearly in the image. They are also the shoes that Mr. Santana is wearing right now. And you can see the picture that he took, it matches the carpet in the back. And I think that is enough.
Picture in the courtroom?
I think so. I'm not 100%, but it is similar to
all right.
that carpet.
All right, well, we're ready to proceed to the hearing.
Needs to be displayed.
All right, can you get them up on the screen? Or?
Let me.
All right.
I'm logging into this.
And Judge.
And Michelle, I'm sorry. I was gonna say, you've seen all this. You've had a chance to look at this. All right.
I want you to see it too, Your Honor, so I can give you the explanation that I think is appropriate.
I'm dying to hear it.
It's taking a while just because the videos need to upload in Unison. So I'll start with this one.
Are you in Zoom?
I'm logging back on.
Okay.
And Judge, just as a heads up, my client about 3 years ago offered to testify on behalf of the prosecutor's office against individuals. He did testify. He now believes that they are doing this to go after him, to cause trouble for him. And his mother, who is present in the courtroom, took his phone back in July of 2025. He has no access to phone. He's on house arrest as well as GPS tether.
All right, let's see the videos.
So he can't.
I mean, how? Someone's not going to be able to make that up, though, Miss. Now, if everything she's telling me is accurate,
we'll see, Judge.
All right, we'll see. Let's look.
And I must say, sister counsel indicated that he does not have a phone and that he hasn't done anything, but he was in my office and he made a comment. I sent these pictures to a group chat indicating he does have access to some phone or a computer or something that can send out pictures.
All right, let me see what we have. So he was put on bond conditions. He was arraigned after multiple court appearances.
Yeah, he's on $100,000 cash surety bond with house arrest and GPS tether. And it's at his mother's house and she's present.
No, I have that the party stipulated to a bond reduction of $20,000, 10% with GPS.
That's not true.
Okay, you're gonna speak, stand up.
Hold on. No, nobody's speaking right now. Just. All right, I see on June 30th, there is a $100,000 surety bond. And so we can see your email account.
It's just taking forever to load. Okay, I will begin with this one. It's a duration. It's just a screen recording provided to me by the officer in charge. This is from September 3rd to September 4th. This was sent to me on Thursday, September 4th. It is 31 seconds. Starting at 0 minutes, 0 seconds.
It's not playing. You have to flip the screen you're sharing.
You want to file free? Hit it.
So it took until 2026 for
Michelle Miller, down there, state your name, please.
Michelle Miller.
Ms. Miller's had the opportunity to go over her rights and rights, and they have no questions on this. She's here on a violation. She is going to enter a plea of guilty. Wish to address the court prior to sentencing, Your Honor.
All right. Ms. Miller, did you go over this 2-page program advice rights form?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And did you sign and date the 2nd page of it?
Yes, Your Honor.
All right. Nope.
No.
It's not signed and dated.
Sorry.
But if you, Mr. Zicki, if you can get her to go over that real quick. This morning.
Yes.
Yeah, thank you, Mr. Kazicki. All right, Ms. Miller, you understand you have a right to an attorney. If you couldn't afford one, we'd appoint one. You have Mr. Kazicki appointed. You understand all that, right?
Yes, ma'am.
And you understand you have the right to a hearing if you wanted a hearing.
Yes.
Yep, and you understand at that hearing, you'd have a right to see, hear, and question all witnesses against you. You'd have a right to be a witness for yourself or remain silent. If you testified, your testimony would be considered by the same standards as everyone else's testimony. And if you chose not to testify, no one could comment on your refusal to testify. And I would not presume or infer that as any evidence of guilt because you exercise that right. You understand that?
Yes.
And you understand you have a right to be proven innocent or to be presumed innocent until you're proven guilty by a preponderance of the evidence. It's a probation violation hearing, so that's 51%. You understand that?
Yes, ma'am.
You also have a right to call witnesses to speak for you at trial or at the hearing, and I would sign a subpoena to get them here if that was needed. You understand that?
Yes, ma'am.
All right. The allegation, Ms. Miller, is that you tested positive for alcohol and had a PBT at 0.07 on August 9th at 9 a.m. And you tested positive for alcohol and had a PBT of 0.06 on August 9th at 9:04 a.m. And that you admitted to drinking on August 8th. How do you plead?
Guilty.
And you understand you'd be waiving the right to the hearing if I accept that plea. There will be no hearing of any kind.
Yes, ma'am.
All right, I'm going to accept the plea as knowing and voluntarily given.
Your Honor, what I'm going to say to the court is not an excuse for her conduct, but I just want the court to know that something that apparently is beyond her control. On the day of the incident, or the day prior to being tested, her daughter was rushed into the hospital for surgery. That was just another straw on the camel's back. She reports in the last 2 months, she's been trying to evict her boyfriend or ex-boyfriend from her house, because of his negative conduct. She's facing a foreclosure. Everything's just been overwhelming on her. She doesn't want to be, or she's asking the court that the court would reconsider about removing her from the sobriety court. She realizes she does need help. She was in rehab last fall and seemed to be doing very well until the end of May when all these problems started multiplying and she had the trouble of coping with it. Yeah, there are 93 days in jail. I'm asking the court to reconsider that. Maybe some sort of rehab program would help her out better. That's all we can say, Your Honor. It's not like a deliberate violation where, some people come into this court and they don't have any reason. They just decided they want to drink.
Yeah.
She's got situations she can't cope with and she needs some sort of guidance and help and begging the court for it, Your Honor.
Here's the problem with Miss Miller, and this is it's very difficult. This is a tough hearing for everybody in the room right now, or at least her and I and Miss Hagner. Miss Miller has this case back from 2021. She was originally on standard probation and she kept drinking on standard probation. She'd never been in trouble before. So that was indicative to everybody involved in the case that she probably needed an elevated level of treatment. So she was brought into treatment court. When she was brought into treatment court, she continued, we had her in an IOP, which was a level of care that the therapist thought was appropriate. And she started escalating. She was not just using alcohol, she started using crack. So then we did everything we could right away, and everything I am saying is true, and you know it. We did everything we could right away to get her better treatment. She got a bed in Naomi's Nest. and went to Naomi's Nest for inpatient residential treatment. She was in for how long, Ms. Havner?
45 days.
Yeah, it was a long, I mean, it wasn't like she was in for 7 days for detox. She stayed in 45 days. She came out, she was gonna hit the ground running. When did she get out, Ms. Havner?
It was sometime in January that she went immediately into IOP.
Yeah, and then we got her immediately into IOP. So she's now done 45 days inpatient, second bout of IOP. She's learning all of these coping skills. I mean, that's what they go there for, right? You're learning all of these different ways that you can react to stressful situations or triggering situations besides use. We got her into peer recovery. She was in IOP. She continued to use. She finished IOP the second time and then went to standard, right? She was just seeing her therapist every week, going to group every week, right, Kelsey? Correct me when I'm wrong. And then she started using crack again.
Cocaine, yes.
Well, okay. And then she had a violation for that in May. She didn't show up for testing in June. She missed IOP in July. She had 2 positive cocaine tests in May after completing a second round of IOP.
Yes, this was within a month of completing, and at that time we put her back into IOP again.
So she's now in her third round of IOP. So she's currently in treatment 3 days a week, plus she sees her own therapist, right?
Once a week, correct?
Once a week. Do you go to that group once a week too? Yeah, okay. You see Sarah still?
Yes.
So she's got a peer recovery coach. You go to her meeting?
Yes.
And you go to AA a couple times a week. So, I mean, other than jail, there's nothing else I can do for Miss Miller. Miss Miller doesn't, we just heard this lady speak at Families Against Narcotics at an event, this opioid awareness month. Beaumont put something on. What was her name? Tiffany Jenkins. And she's in recovery, and she talked about being in recovery, and she said she did 2 inpatient stints. The first one she did it because the government told her she had to avoid jail. And she went through the motions, she did what she had to do, and she got out. The second time she did it, she had completely hit rock bottom, and she knew she needed to change. And that's when she quit using. And Miss Miller, I don't know where rock bottom is, but she's not in this program. It's clear to me she's not using any of the resources we've thrown at her because she just continues to have use violations. She has all of these tools, all of these people she could call. She knows she could come sit in the court if she wanted to. She could call Kelsey. She could call her peer recovery coach. She could call her therapist. She could call one of the 15 girls in our peer group, in the women's group that I know she has relationships with. And she could have done all of these things. She could have went to a meeting. She could have used all of these tools, and instead she decided to use, and then she came to court drunk, knowing full well she's still drunk from the night before.
Yeah. That could be another cry for help. I know that there a lecture that you heard, the lady went 2 times to IOP. This may be her rock bottom, and it'd be a shame to give up hope and to throw her in jail, just throwing her to the wolves. Also, Your Honor, if I could just mention, if the court is going to incarcerate her, if she can have a startup date. She's got 2 minor children at home, and the child's father is finally doing something. He never supported him, but he's filing for custody. So she does have to make arrangements for those 2 minor children.
Yeah, the problem is with keeping her in any capacity is we don't have time. She's got to have, we have phases in the program. She's in phase 2.
Right.
So she just had a violation. So now it'd be 90 days without a violation before she could go to phase 3. And then she's supposed to do how long in phase 3, Ms. Havner?
Minimum of 3 months.
A minimum of 3 months. And so that altogether is 6 months that we need. And how long do we have her?
Until January 5th, so about 5 months.
We don't have time for her to graduate. We don't have time for her to finish the program.
And if they're successful during that time, they'll be well worth it though.
And that 90 days is also guaranteed that there is no further violations or use violations. So it's not even a guarantee to advance within 90 days.
I know I'm not actively involved in sobriety court, but my understanding is incarceration for long terms really does not help in addiction.
It doesn't, but neither does keep helping and helping and helping someone who doesn't want help. Like at some point, it's like I'm just screaming off a mountaintop. She's not listening. She's not taking advantage of any of the resources. I just don't see the point in it. And it's heartbreaking and it's so sad. And Miss Miller's been with us for a long time, and it's like we start to see her make progress and then she reverts right back. And she's reverted right back to the point where I don't know if I can keep her. And I don't think she's expecting this. I think she thought she could use, and it was gonna be like all the other times. But now time's running out. And if she's not learned anything yet, I don't know that she's going to.
Yes, I mean, that's kind of where I'm at, Judge. I mean, you know, they say incarceration is not gonna help, but clearly recovery is not helping her either. She did reach out to her peer recovery coach that day, but she didn't even talk to her about wanting to use or about to use. So, I mean, if she's not gonna take the step further to tell people, hey, I'm at my rock bottom, this is what's going on, I don't see how much else we can help her if she's not utilizing her tools to the best of her ability.
Yeah, today's not an eye-opener for Ms. Miller. Nothing would be. And the court still has time to keep her in the program. And, down the road, 2 weeks, 3 weeks, you can still throw her in jail for 90 days.
Miss Havner, didn't she just do 5 days in county on her last violation?
She did 4 days, Judge.
In Wayne County Jail. Look at little Miss Miller. If 4 days in Wayne County Jail, and then how long she been in now?
5. So she did 4 days in Wayne County Jail in May, and the same day that she came out, she used cocaine.
I'm sorry, it was 2.5 days I was there.
Okay, so 2.5 days later, and she got right out and used, so that didn't work. And then she's been in for 4 or 5 days now.
That sort of supports the argument that the jail doesn't help in addiction.
Yeah, right, but neither does therapy in Miss Miller's case or any of the other tools she keeps using anyway.
She had a couple months there where she was sober and no violations.
I mean, when we're 18 months along and she's still not using her resources, I mean, that's very alarming.
Yeah, I mean, at this point, these should be proximate goals. Like these should be things that she's able to do. I don't know, Miss Miller. I can't see any.
I did put the minor children's father on the consent form, so I can call him following this hearing and arrange contact.
You'll love that.
For the children, so the children will be fine.
It's,
And then the other 2 are adult children.
I'm sorry. It's an individual who barely supported the children, and now he's trying to seize on this opportunity. But
It is what it is.
It is what you made it.
Yes.
It is, it's
Yes.
what you made
Yes,
it,
Your Honor.
Miss Miller. This isn't, it is what it is.
No.
This is your reality because you created
Yes,
this
ma'am.
reality.
I apologize for saying that.
I mean, this is, is it good for the kids, for the ma to be, doing crack and coke and drinking when she's looking at all this jail time? These are rhetorical questions. I mean, we all know the answer. All right, I'm gonna call this other matter. Miss Miller can just sit for a minute. That's according to the guidance center. Like they can't think of anything else other than 3 stints in IOP and a residential that would help Miss Miller, learn some coping mechanisms or deal with whatever trauma she has, and this is still her first response, even with everything that we've provided. I'm gonna give her some credit for the time she's been in the program. I'm sorry, Kelsey, I lost your paper. Ms. Miller, you can still do this on your own when you're ready. If you continue down this path, I'm confident I'll see you again. What?
I don't want to be like that anymore.
All right. I'm gonna give her 80 days.
This season, you've got places to
No, I think now.
Okay. All right, Mr. Beisel, I see we've got you here. This is 240147FY, the People versus Rick Good. Can I get appearances?
Good morning, Judge. Max Beisel, P77513 on behalf of the people.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125 on behalf of Mr. Rick Good. Your Honor, I don't see him on Zoom. I don't know if they've Zoomed him in. I would ask to waive his presence for this proceeding.
All right, we'll waive his presence. I don't have him logged in. But I've received yet another report dated November 25th from Andrea Vandenberg at the Center for Forensic Psychiatry. Have both of you received a copy of this report?
Yes, Your Honor.
Oh, okay, and again, we have the same basic findings. I feel like we've seen before that it's their opinion that he's not competent, but that competency can be restored. No, you go, Mr. Riggins, go ahead.
To that, Your Honor, I have, as I've stated, it is obviously I'm a lay person, but it's my opinion from speaking with the family that Mr. Good may be suffering from dementia. I have emailed the court, and the court was graciously signed my order to have him seen by a neurologist. My apologies. But the problem now is the Wayne County Sheriff. Your Honor, originally the Wayne County Sheriff initially rejected me getting a neurologist in to see him. Once you sign the order, they said he could come in, but they only gave me said Monday through Friday. The problem is my neurologist is a actual working neurologist with an office, and he can't make those hours without shutting down the day of his practice. He offered to come on the weekend. They said that the weekend doesn't work. So my next solution, quite simply, is to have the Wayne County Sheriff transport him to the neurologist, have him treated, and transport him back. Your Honor, my neurologist is located in Clinton Township. Again, he is a working neurologist. It is a medical facility. I don't think there would be a hardship on the county, as they are currently in the care and custody of Mr. Good. And it will resolve, I think that would resolve the question of whether or not he is truly restorable or not.
Mr. Beisel, do you have any opinion on this?
I would leave to the court's discretion how they want to handle that. I know we still have time left for the forensic center to restore him. If we get to the point where he's not been restored, then the people may have a different opinion.
Yeah, I mean, we're getting really close. And the fact that the forensic center still is saying they don't have a bed for him. I mean, he was arraigned on, it'll be a year. They've got 15 months. So they're going to magically, I mean, it's outrageous to me that they're going to magically get a bed for him after he's been waiting for 1 year, and they're going to find a bed and they're going to restore his competency within a month. I mean, this case is ending up in probate. I mean, it's abundantly clear to me at this point that that's what we're doing. But we have to wait for this time frame to lapse. I mean, that's what's happening. And I know you both, I mean, we can read the tea leaves on this. Like, it's crazy to me that we have someone that the forensic center says is not competent, is in need of treatment. The government has no place to put this person to give them treatment. And we have someone who may or may not be suffering from dementia sitting and basically languishing in the Wayne County jail.
Amen, sister.
Miss Good, I don't need help.
Oh, I'm sorry. I thought I was muted. I'm so sorry.
All right.
I didn't know I was unmuted. I'm so sorry.
Just mute yourself. I can do my job.
Yes, I will. I'm so sorry.
It's okay. I've got a choir with me, but listen. Here's the thing, Mr. Riggins, I suggest you draft an order, and you can say in that order that one of two things is happening. We'll give the county an option. The county is going to give access to this neurologist during non-business hours, or they're going to transport him within whatever time frame you think is reasonable, 2 weeks, 30 days, to this facility so that he can be evaluated. And I don't care. They give him a choice. You either give access within 30 days, you schedule this appointment that works at a time for the neurologist in the facility for whatever time frame your neurologist says he needs. If he needs a 5-hour block of time, put it in the order. Be as specific as possible so we can say to them, you're doing this or you're doing that. And we don't care which one it is, but you're doing it in 30 days.
Thank you, Your Honor.
That sounds reasonable to me.
I will have that order to you, and I will CC Mr. Biden before the end of the day.
How do you get a brand new roof in Central Alabama?
Okay, and I'll sign it. I mean, I think 30 days, whatever block of time he needs, that or within 30 days, they work with this doctor or you work with them to make sure that he receives treatment at the doctor's facility. But either way, this is just crazy.
I would agree.
This is like a fracture in the criminal justice system that it's unacceptable.
Thank you. I will have that order done today.
And then I guess we just set another, I mean, are we just going to continue for the next 3 or 4 months, whatever time they have left? What do they have left? 3 months? Are we just going to set another hearing in 30 days or 60 days until this case goes to probate?
Well, I'm hoping that once I get him to the neurologist, I can get a quicker turnaround date. So maybe 45 days out. And if we get a report sooner, we can come back sooner.
Okay, okay. So let's just pick a day 45 days out. December 16th. So we're looking at the end of January or like February 3rd.
Either day, January 31st, February 3rd, either day works.
Yeah, well, my docket's either January 27th or February 3rd. So let's do January or February 3rd, just so that gives your time, the 30 days plus time for your person to write a report. All right, we'll return February 3rd, 25. I can't wait for you to violate. I'm looking forward to putting you in jail for the maximum possible time. So violate, give it to me.
Good morning, Your Honor. Jacob Bloomer on behalf of the people, P77307.
And good morning, Judge. Neighborhood Defender Service by Glen OP 83424, appearing on behalf of Mr. Halfman, who is present in the courtroom. Mr. Halfman, please state your name.
Matthew Hoffman. And Matt Key is on behalf of probation.
All right, so we're here today. Well, is the sentencing also supposed to be set today, Mr. Keys?
He is scheduled for sentencing as well as the bond violation.
Yeah, so we had an allegation he violated the terms of his bond. One of the terms of his bond was he was to have no contact with Alicia Halfman. And the allegation alleges that defendant contacted the victim, Alicia Halfman, by phone from probation officer's phone on 9/24 and had Ms. Halfman send an email to the probation on 9/24 on his behalf. Mr. O, how are we proceeding on this?
Bond violation, Judge, it was my understanding from the court, it stated explicitly no contact with the children, whether it be supervised or unsupervised. There was no mention of order between Alicia Halfman and his wife. Alicia Halfman was also not a complaining witness in this case. It was just the children.
I have my bond
So I was
conditions
confused.
are. The bond conditions are, and the bond conditions that he was given. Do not assault, harass, intimidate, beat or wound. She's listed here, hold on. Do not have any contact. Do not have or cause any third party to have any direct or indirect contact with the following persons. Cooper Halfman, Alicia Halfman, and Makia Halfman. That's what's on the bond paperwork.
Never ever sue the other driver.
Understood.
I'm reviewing it.
That's
Mr.
not-
Keys, was he given a copy of the bond of the conditions?
I'm assuming he was given a copy upon release from custody, but I cannot confirm that.
Do your client get a copy of his bond conditions or normally given to them upon release?
So I can speak on that. The bond violation allegation only came about after Mr. Halfman was in the probation department and allegedly called the number associated with Alicia Halfman. After that, Mr. Keys contacted Mr. Halfman a day or two afterwards and said, Mr. Halfman, I'm going to violate you. You violated the no contact order, and Mr. Halfman was equally as confused as I am. And also, we're not necessarily conceding that there was a bond violation allegation.
Judge.
I'm sorry, Mr. Oh, you broke up there. What'd you say?
For a second.
Breaking up.
If I may,
You're breaking up real bad.
if I may speak while his connection is fixing, I would just to kind of reiterate Mr. O's point. She may have been listed on the bond conditions, but she is not a victim in this case. She was not even present when the crime was committed. I'm not, so I can't say for sure, why she was listed as a no contact person, but we may want to even address whether that should be a condition of probation or not, because again, yeah, she was not even present for when it happened. The concern is between him and his son. And that was, what this case was about and everything else. If he and the mother have a working relationship at this point still, I don't know that we need to forbid contact between them so long as he's honoring the other terms of the sentence agreement that he pled to.
So the prosecutor doesn't want to proceed on the violation?
For strictly for contacting the mother of the victim in this case, no. I based on what I see, I don't see anything that suggests that he was contacting her to, intimidate or anything like that. So I don't think it's necessary to proceed on that no contact violation. And again, I'm open to addressing whether that should be a part of his sentence or not.
All right, well.
Matthews lift 2945. It has a
Mr. Vizicki, you're not muted. All right, well, I mean, if the prosecutor doesn't want to proceed on the violation, there's no violation. So the violation's dismissed.
Thank you, Judge. No objection.
All right, so now, as to sentencing.
Judge, we have had an opportunity to review the report. There are no additions, corrections, or deletions. We're asking the court to follow the agreement.
Anything on behalf of the people?
Your Honor, likewise, no additions, corrections, or deletions. The people would ask the court to adopt the terms of the agreement.
Mr. O, anything you or your client want to say before I impose sentencing?
No, Judge.
All right. All right, Mr. Happen, this is the second time you beat your kid. You have a conviction in 2019 for child abuse. I mean, menacing charges, pending, disorderly conduct charges. And you take absolutely no responsibility for what you've done? No, you don't. I'm reading the report. Mr. Hackman does not accept responsibility for his actions and offered justifications for his actions numerous times over the course of the interview. He minimized his role in the offense and claimed that the victims were not being truthful in their reports. He minimized his role in He reported that he only pled guilty to get out of jail. He disputed nearly everything that was listed in the police report. The defendant has a history of violence, with domestic violence charge being amended to a disorderly conduct, a prior abuse 4th degree. He reported the prior abuse occurred when he spanked his child. However, the police report for that offense indicated that the victim had bruises on his eyes, face, and arms. And this allegation, you were choking an 11-year-old? Is that what it was?
I do not recall the age of the victim in this.
Are you researching dental implants?
This is a second offense. The prosecutor offered a plea agreement to a year probation. And I have a problem with that sentencing agreement. I've got a guy in front of me who's got prior assaultive convictions, a prior assault for beating a kid. He's here today again for choking a kid, and he gets a year probation. I mean, how many chances does he get? Do we wait until he kills a kid before he gets some jail time?
Well, Your Honor, I did state this at the time of the plea, and I'll state it again. You know, his guidelines are probationable. There were no injuries in this case, and the mother, Alicia Halfman, who we've just discussed, was not interested in pursuing the case or pressing charges. Based on all of those factors, we did determine that this was an appropriate plea offer for this case. The hope of my office is that he will take the alcohol counseling and the parenting classes seriously and turn this around and become a good father for his children.
What happened? There's a sentencing agreement. The best thing you could do for your children is stay away from them, because you've got a problem. You should go to jail today, but I'm going to follow the sentencing agreement, because if not, you would draw your plea, and then your wife doesn't bring the kids in to testify, and the case ends up getting dismissed and you get nothing. So I'm going to follow the plea agreement today, or the sentencing, but I'm going to tell you that I can't wait for you to violate. I'm looking forward to putting you in jail for the maximum possible time. So violate, give it to me. Because the minute you violate, I'm putting you in county for the maximum possible time. I want to be clear. I want to make sure you understand. Give it to me.
I understand, Judge.
Fine of $50, court costs of $50, state costs of $50, crime victims' rights fee is $75, probation oversight fee of $450, community service fee of $10 a day for a total of $100. Total due $775 to be paid in a payment plan, 12 months probation, 10 days community service in the city of Taylor as directed by probation and provide proof. Additional 2 days of community service ordered on, is this still in here, or is that from that?
That was for the previous bond violation that he had on the 24th of September.
What was that one for?
Testing positive for alcohol.
Oh, this is good. Okay, good. So he's working towards it. Okay, good.
Sure, ma'am.
All right, I see it. Okay, you've already done those 2 days?
Yes, ma'am.
All right, and I'm reading in the sentencing, but you can provide the proof to Mr. Keys that you've already done that, okay? And you'll
Yes,
get
ma'am.
credit for it. Additional 2 days of community service ordered on 9/24 at bond modification hearing. Abstain from the use or possession of alcohol or controlled substances unless prescribed by a physician. Documentation will be required. And that's the term of probation with random drug and alcohol testing as deemed necessary at your expense. You'll complete outpatient substance abuse treatment as directed by probation and follow therapeutic recommendations and provide proof. You'll complete anger management as directed by probation, follow all recommendations and provide proof. Mr. Keys, what's the longest class they have?
I believe, look to see if it's 26 or 52 weeks.
I'm writing longest class. You'll complete parenting classes as directed by probation and provide proof. You'll obtain employment and provide proof. You'll comply with the CPS order. You'll have no contact with, so the prosecutor has no objection to him seeing his wife, right? Alicia Halfman?
No, I have no objection to speaking or contacting Alicia Halfman, yeah.
All right, I'm striking Alicia Halfman from the no contact order. You can have no contact with Cooper Halfman, Maddie Halfman, or McKeo Halfman. No weapons or ammunition, clear outstanding bench warrants, no driving without a valid license, and order for fingerprints if applicable. I'll see you soon, Mr. Halfman, and when I do, come prepared.
All right.
Anything else?
Nothing for the people, Judge.
Not from the fence.
You're done. I'll see you next time.
Mike Kaplan.
All right, just like last time. Keep your hands in there, don't touch anything, all right?
All right, this is multiple cases, 200434, 200419, 200418, 193992, 251160, 252332, and 252331. The People versus Charles Denkins Jr.
Yes, Your Honor. Can I please speak to you? Your Honor, listen, I have this thing on my leg. It's a tether, and it keeps telling me what to do. It keeps telling me to do bad things, and I don't want to. This is the thing. I got a tether on.
Mr. Denkins, can you just come back where I can see your face, please?
Yes,
I can't see. Back up to the glass because I don't need to see all of you, just your face.
My face is right there, man.
Can you? Okay. Well, officer, I can't see him on the iPad. It's showing the door.
I want to speak to you, Your Honor. That's why I got to speak to you.
Mr. Denkins, take a breath, okay? We'll get through this. But I can't see him. All I can see is the wall or the door.
He's saying that he won't put it back in front of me.
Mr. Denkins, you need the speaker back.
I'll give it back to you when I'm done.
Okay, we lost the jail.
If we can do a forensic on it, maybe.
Seems like that's appropriate. So of any of these cases, these are all arraignment pre-trials. I don't see that he's ever come back to court on any of these. So some he's not been arraigned on. Some
He's got a no bond too out of Wayne County.
yeah, and he's been arraigned on some of them and just went into warrant status. Let's see if we can get the jail back. All right, Officer Ziegler, are you ready?
Sure, Your Honor. How about you?
I hope you're doing okay over there. I'm guessing that you're not.
Actually, I'm all right. So okay. We'll get back to him in a little bit.
Okay.
I'll figure out how you want to do that. This.
I'm thinking, I think we're just going to ask for a forensic.
That might work.
Yeah, I mean, well, he's going to have to. And I don't know that he's even comprehending his, I mean, I haven't had a chance to get him to, I couldn't see his face the whole time. The camera was like at the door. So all I could see.
He kept reaching through and moving. So he was grabbing stuff and pulling it in the cell and pushing stuff around. So I can't have that.
I hear you. Maybe we'll try one more time with him, but let's see.
You want to do it, Mr. Jenkins? I'm really not interested in opening that cell again.
You have to open it for me to see him, yeah?
Yeah.
Okay. I mean, let me just say on record with respect to Mr. Jenkins' arraignments, I made attempts to arraign him. It's clear that he needs to be assessed for competency. He appeared to be delusional and combative. I believe he said something about hearing voices telling him to do evil things or something of that nature. I could not properly arraign him. It's my understanding, is he throwing feces over there?
That's correct, Your Honor.
Okay, well, I'm not going to put you through that. It's clear to me that he cannot be arraigned based on his current mental condition. So on each of these cases, on each of them, I'm giving him, here, I'll make it easy. Let me find the one. On the case 251160, this is the larceny out of Home Depot. On that case, he has $1,000 cash bond. On 19392, he has $1,000 cash. I'm gonna just do 1,000 cash on all of them so we can get them assessed.
So a total, I'm sorry.
1, 2, 3, 4, 5, 6, 7.
So 7,000 total?
7,000.
That'll work, Your Honor.
All right, thank you. Who do we have now?
This is Mr. Mack. Mr. Mack, come on up here to the door. Keep your hands inside the cell, all right?
All right, this is 242414, the People versus Jamie Massa.
Good afternoon, Your Honor. James Gazicki on behalf of Mr. Massa, waive reading of the complaint, stand mute. Your Honor, his address now is at 14180 Huron. That was the location of where the charge originated at. His mother, who lived there, passed away about a month ago. So he's at the house, taking care of the house. He's also requesting a court-appointed attorney.
All right, I've signed the request for a court-appointed attorney. Mr. Massa, did you sign your advice of rights form here? Did you get, I'm sorry, did you go over it with Mr. Gazicki? No. Did you understand your rights? And did you give him permission to sign that form on your behalf? Okay, so I've entered a not guilty plea for purposes of arraignment. Again. And then, is the complaining witness on the case his mother?
Yes, that's what he indicates, and she passed away. I don't have any documentation to confirm it, but I assume that's what it is.
You don't have low testosterone.
I mean, this is concern. Here's the thing. I've seen him before. We've had all these dates. I told him just show up to court. I gave him a personal bond and 24 hours to provide the court with an address, and he had the same conditions. That was on December. He never came back. So he's a flight risk. I also see he has warrants out of Southgate, Dearborn, and Canton. And he just doesn't, I can't trust that he'll listen. I gave him the benefit of that. And he does what he wants. And he just doesn't come back to court. And it's not just us. He doesn't come back to any of the courts.
I apologize, Your Honor. Yeah, burglary charge. I didn't even know that.
Okay, so he's got cases out. What is this? What day of birth? What's your date of birth?
033095.
Right. So he's got warrants for failing to appear on resisting and obstruction, paraphernalia. He's got it for open intoxicants in a motor vehicle. He has our case. He has one for fraud. He has one for a license offense. Another one for not stopping at a crash. And he just doesn't come to court. So I'm taking away the personal, I'm giving him the 10% provision. So now his bond is 2,000, 10%. With the same bond conditions you previously had, sir. And if there's proof that the complaining witness is deceased, that information needs to be given to your attorney. I signed the request for a court-appointed attorney. You need to get it to the attorney so that he can give it to the prosecutor if the case is ultimately being dismissed. We're all set.
Your hands inside the cell. Keep your hands in there. Stand up. Nope. Stand up. Put your hands inside.
Can you hear me?
Yes.
All right. You're here today charged with misdemeanors. You have this old case that's in warrant status. There's an allegation that on April 2nd of 2025, you violated city ordinance by driving on a suspended license. That's a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. Then you have this other charge, another City of Taylor charge. There's an allegation that on April 2nd of 2025, you were in possession of a controlled substance. So you have that case, that's a misdemeanor punishable by up to 90 days and $500. Then you have another driving on a suspended case. And again, that's a misdemeanor alleged to have occurred on April 11th of 2023. And that's in warrant status because you were given a payment plan 2 years ago. And I'll go on ahead and guess that you didn't make any payments on that. You did. It looks like there was a bond forfeiture and a tax garnishment filed, but otherwise you had it. Sir, I have to go over your rights with you. You understand you have a right to an attorney. It's my understanding that you've waived that right and you do not want to meet with the attorney.
Judge, there's no need for it right now, ma'am. I'm not wasting court's time.
All right, well, that's not wasting the court's time. That's ensuring that you're advised of your constitutional rights, sir. That's the opposite of wasting the court's time. So here we go. Sir, I've advised you of the charges against you and the maximum possible penalties. I should also advise you that you have traffic ticket that's also in warrant status. It looks like you have a disobeying a traffic signal that's also in warrant status for non-payment. Sir, you have the right to an attorney at public expense. If you can't afford an attorney, one will be appointed to represent you. You also have the right to you may have to repay the expense of the appointed attorney if the court determines you were able to do so. If you have a right to a trial. And at the trial, you would have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court requiring witnesses to come to court. You also have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights, sir?
Yes, ma'am.
Okay.
You have a right to be released on bond if it's appropriate. I see that you have, two of these are driving offenses. The other one's a misdemeanor possession case. But Mr. Oliverio, you also have Romulus warrants, Allen Park warrants, Lincoln Park warrants, and Dearborn Height warrants. Let me see what your warrants are for. Oh my goodness, though. This is your criminal history. Look, sir, you started your life of crime like in the 90s.
I stopped committing crime. Again, I'm on Social Security, I'm on disability. My life of crime stopped a long time ago. I got caught driving without a license and some drugs, and that was it. I stopped breaking houses, all that shit a long time ago. I'm sorry for my language. It's all adding up, and I know it's petty.
Though, because like I don't want you cussing. Like, calm down. We're having a discussion.
I'm not trying to commit crime, man.
Listen, but you understand when I'm setting bond, I try and look at whether or not you're a danger to the community and a flight risk. Like, these are reasonable things for me to be looking at. So let's see. You got a brandishing a firearm case.
Oh my God, man. There's everything. Oh my God. There's a BB gun. Are you kidding me?
You have a, listen, Mr. Oliverio, listen to me. You have a right to remain silent. Don't tell me what kind of gun it was, because you're saying things to me that could be used against you in your other case. Just, can you listen to me? Okay, I'm gonna just talk over you if you won't listen. You got an open intox warrant out of Romulus. You've got a traffic warrant. It's this Lincoln Park one for driving on a suspended. I'm not worried about that.
Yeah, I'm sorry. I'm under a lot of stress. I ain't taking my medicine before.
Listen, you have a fraud warrant out for out of Allen Park. You got a fraud warrant out of Lincoln Park. You got a larceny out of Lincoln Park. You got a felony out of Dearborn for dangerous drugs, the felony. And that's a warrant, and they're going to pick you up, I'm sure. And then you got another one for retail fraud, 3rd degree. So these are all the bench warrants that you have pending.
It says I have all this stuff going on, Your Honor. I release on my own account, personal bond. I take care of all this other stuff that I was unaware of. I don't know how all this is happening to me right now. I feel like this is just too much. Sweating down here. My meds, I'm off my meds for 4 days. I obviously I got a lot going on. I can take care of a lot of things here. So.
All right.
It's overwhelming.
I hear you. I mean, but this is a mess of your own making. You don't show up to court, and then you got all these places that want you. So the failing to display a valid license, that's not something I've ever given anyone jail time on. In that case, I'm just giving you $1,000 personal bond. All right, and that's on 0798. Don't thank me yet. Then I've got the driving on a suspended, that's 1063. Setting aside all these warrants, obviously. On that one, I'm also giving you $1,000 personal bond. All right, and then you've got this possession of controlled substance case.
That this possession, it was yesterday.
Hi, okay, yeah, it was, no, this is on April 2nd at 25. You might be pending new charges. I don't have them yet. These are on your old charges, but on that case, I'm not giving you a personal bond because you don't come to court and it's the allegation is you had meth on you. Might explain some problems, sir.
I got
on that case, You have a $5,000 10% bond. These are your bond conditions. You're to appear in court as directed, not to leave the state without permission of the court. You're not to commit any new crimes while released. Sort of change of address or phone number. You cannot possess access or have access to firearms or dangerous weapons. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. So those, and you also can't operate a motor vehicle without a valid license, which goes without saying. So we'll get you a court date as soon as possible, sir.
Well, thank you so much to the people who did watch. I'm going to go ahead and call this one for today. I will see you guys tomorrow, which is Judge, let's see, Judge O'Donnell. So I'm calling this one. You guys have a wonderful evening. Ta-ta and ciao-ciao, and I will see you guys on the next one. Have a good evening.